Our first of the practitioners is David Gardner, who's a barrister at number 5 Chambers. David represents both claimants and defendants in judicial reviews in the Court of Appeal and in the Administrative Court. He also appears regularly in the Court of Protection and in the immigration tribunals. And he's also appeared in a number of other jurisdictions, including education matters and criminal cases, as well as parole board hearings. Before he started his career at the bar, David was the sole administrative court lawyer for Wales and the south of England between March of 2009, when the administrative court in Wales launched, and October of 2017. In that role, he gained an incredible wealth of experience in judicial review and administrative law challenges, and was responsible for case management of those hearings, as well as assisting and providing the judges with advice on particular cases. Prior to his role with the Administrative Court, he was a legal advisor in the Magistrates Court between 2005 and 2009. And by virtue of that wealth of experience that David has acquired, he's often tasked with providing training and advice on judicial review practice and procedure. And he's done that for a number of beneficiaries, including the National Assembly for Wales legal team, the Welsh Government Legal Services Department, conferences such as Legal Wales and the Public Law Project, the South West Administrative Lawyers Association, Public Law Wales, and Bangor University. And he's also on the Equality and Human Rights Commission panel of approved counsel. So, David, over to you.
Thank you very much, Mona. I've been given 5 minutes to talk about judicial review and discrimination, so I suspect my introduction is as long as my talk, so thank you very much, that's very kind. I really want to use just a brief period of my talk just to say, firstly, and then as an aside, I want to welcome Angharad to the Commission in what I think is a really progressive role on the Commission's part. Having a full-time lawyer in Wales is, I think, really important. So well done to the Commission as a start, and congratulations and welcome, Angharad. In terms of my particular topic, as has been introduced, my specialism is judicial review, and in my view, it appears to me, discrimination isn't a matter that comes up frequently enough in judicial review proceedings. So I wanted to use my short time to endorse the idea of looking for discrimination cases within judicial review. I won't go through all the acts, as the judge has done so in greater detail, and I'm sure far better than I could do. But it's important to know that those points, direct discrimination, indirect discrimination, breach of the public sector equality duty, are in statute, they are law. And if you act unlawfully, ergo, you may well find yourself in judicial review proceedings in the administrative court. So, how best to encapsulate this in my short time? I thought perhaps the best way to look at this is the way, as is often said, society can often be judged by how it treats its prisoners. So I wanted to have a look at just a couple of cases, one of which I've been involved in, one of which I have not been involved in, really dealing with how prisoners have been treated and Equality Act claims based upon their treatment. So I would endorse going off and reading another Supreme Court case, which is the case of Cole, the 2017 case. That's a case in which it was set out that female prisoners, and shown quite clearly that female prisoners don't have access to the same number of approved premises for release on licence. That means that when they were being released from prison on licence, they were often being distributed all over England and Wales, sometimes really quite far away from family members. This was brought as a discrimination point. Clearly it wasn't happening with men, but it was happening with women. And that went through High Court proceedings in which it was heard, actually interestingly, here in Wales to begin with, because it was linked with a case of Griffiths, a High Court decision of Griffiths, and actually heard in Port Talbot. High Court held that the public sector equality duty had been breached by this lack of the Secretary of State for Justice looking into whether the availability of approved premises was an Equality Act issue. It wasn't advancing, it wasn't promoting the these discrimination points. And so as a result, it was that was a declaration that came out of the High Court proceedings. The Supreme Court, as I say, ruled on it in 2017 and did find, first, made no comment on the public sector equality duty because that wasn't specifically appealed, although it was noted by the Supreme Court that still no justification had been brought forward by the Secretary of State. There's also a finding within there that without justification for the reason why there was no looking into the availability of approved premises for women, that was held to be direct discrimination. Now, my view as a lawyer coming to this, someone who's worked in the administrative court, is there are a number of grounds you could potentially have pleaded that under. Immediately your mind goes to human rights types of grounds, but I think it's important to know that that's a discrimination case that's made its way all the way to the Supreme Court. So it is an available option in judicial review proceedings, and you can be challenging the highest levels of policy using such grounds. That's the plus. I very briefly wanted to mention another case that I've been involved in, which involves a life prisoner. He was sentenced to life imprisonment for murder back in 1996. He spent 23 years in prison and was then released on licence. On licence, at his approved premises, he suffered what we term a mental health breakdown, in effect. It wasn't a violent breakdown. There was no violence involved, but he essentially descended into uncontrollable sobbing. It became such a concern for those persons in the approved premises that he was then taken to hospital and he agreed to be an informal mental health patient. He was an informal patient, section 131 of the Mental Health Act. Almost a day or so after his informal admission, the Secretary of State recalled his licence on the basis that his risk was no longer manageable in the community. Now, my grounds were relatively lengthy, as I expect you can all guess, but I will really just summarise the position as this. If someone hasn't been violent whilst on licence, and they've accepted that they have an issue that they need informal treatment for, where is the risk arising out of their actions, and should he have been recalled? Now, my point, I suppose, is the risk factor is in legislation. You have to consider that. But has he been treated differently because of his mental health in that situation? If you have somebody who is not violent, normally they're not going to be recalled on licence. All you have there is somebody who has been uncontrollably crying. You have somebody who's trying to deal with their mental health issues, and they have been recalled on licence as a result. I pose the wider question, I suppose, has he been discriminated against? And secondly, because there is a relative lack of assistance, a relative lack of guidance in the recall provisions and guidance on how to deal with prisoners with mental health issues, has the public sector equality duty been breached? Now, probably not the best thing to say at this stage, but I've just been refused permission on the papers on that case. So we'll see where that goes. But I really wanted to be honest and say we need to have a bit of a think, I think, both in terms of the executive and in terms of how we're bringing cases. Because my view is I don't think that Discrimination and Equality Act grounds are being given the credence that perhaps they should. They're not well known enough, and they're perhaps not being properly explored. So, are we in a position now where we need to say, we need to challenge this? How do we do that? Events like this is how we go about challenging that kind of misunderstanding. Bringing cases is how we go about challenging that type of misunderstanding. So I hope that by holding events like this, by having practitioners available who you know you can turn to, be it as a prisoner or be it in any form of judicial review proceedings, you know where to turn. So thank you very much.
Thank you very much, David. Our next speaker is Keris Walters. She's a barrister from Number 9 Park Place Chambers. Keris's practice is predominantly in civil litigation, regulatory and family finance matters. Her civil litigation practice covers chancery work, including trusts and land disputes, as well as commercial disputes featuring landlord and tenant and insolvency matters. She's also experienced in housing matters, and in 2016 she represented an appellant tenant in the civil division of the Court of Appeal in the case of Lee Flowers and Cardiff County Council. It was a case which considered the interpretation and scope of changes to Part 83 of the Civil Procedure Rules relating to issuing of warrants of possession that were brought into force in April of 2014. She's been noted and recommended in the Legal 500 2018 edition for her property work, particularly building disputes and adverse possession matters, whilst in the previous edition she was recommended as being very experienced in housing matters. She too is on the Equality and Human Rights Commission's panel of approved counsel. Keris, over to you.
Thank you, Mona. And can I start off initially by echoing the sentiments of David regarding the welcoming of Angharad, and certainly, hopefully, what signals the importance and the increased importance on equality and discrimination matters within the local area. What I'm going to try and do with my 5 minutes is give you perhaps a practical example of the sorts of cases I deal with that involve equality and human rights issues, and that is predominantly in a housing capacity, in my experience. Most of my work in housing is social housing, and by its very nature and the manner in which social housing is often allocated, a large proportion of tenants in social housing are vulnerable tenants. The majority of my work, not exclusively, but the majority is defendant-tenant focused. And so a typical client for me will be, I'll refer to him as Mr. Smith. He will be someone who has a disability within the meaning attributed by Section 6 of the 2010 Act, for example, a mental health issue such as paranoid schizophrenia. And as part of his disability, he will, for example, have aural hallucinations, which may cause him to react noisily at all times of night, middle of the night, early hours of the morning. And what that means, or what that corresponds to in a housing context, is that you have a social housing provider who is then having multiple reports from various neighbours who are upset because there is what is simply termed as noise nuisance and antisocial behaviour. And as that then continues, it ends up whereby the social housing provider takes action in the form of serving a notice to seek possession, followed by a claim then, usually in the county courts, more often than not before a district judge, but sometimes these matters come before circuit judges, where they are seeking possession against this tenant. Now, many of these tenants initially turn up unrepresented. They will be, again, I have to say, my experience, and I obviously only come into it once they are represented, but my experience is generally that certainly the courts are very good, as are in fact the representatives of the social housing providers in pushing tenants towards seeking legal advice, providing the names of representatives who have legal aid contracts and can provide appropriate representation. So that's generally where a solicitor will come in and I will closely follow, usually at the time of drafting the defence. And what we tend to do then during those proceedings is to seek medical reports, generally from a consultant psychiatrist. It's often a single joint expert report who will be able to address issues such as whether somebody is suffering from a disability, what impact that disability has on their behaviour. And so the vast majority of those sorts of cases and the types involving Mr. Smith will be ones that centre around the Section 15 disability discrimination that was referred to by His Honour earlier on, where someone is treated unfavourably as a result of something arising in consequence of their disability. And so Mr. Smith, for example, is being or he is being treated unfavourably in that he is having possession sought against him because of something arising in consequence of his disability, and that is his inability or his reaction to his aural hallucinations at times that he can't necessarily control. And so what that then does, of course, is provide almost a prima facie finding that there is discrimination unless the social housing provider can show that that is a proportionate means of achieving a legitimate aim. So it adds in that additional layer of protection for the defendant tenant, and one which may not come about were he not represented and were these points not taken. And quite often, these sorts of decisions will be fundamental to those tenants involved. Of course, losing someone's house is always fundamental and is always an issue that's going to impact gravely. But often, for example, using Mr. Smith's case, Mr. Smith was someone who, unfortunately, as part of his disability, didn't recognise that he had a disability, didn't recognise that he needed to take the medication that the mental health services were prescribing to him. And so for that reason, at one point, Mr. Smith became entirely unmedicated and ended up under section in a hospital as a result of an attempt to commit a violent offence. And what that means then is in cases such as Mr. Smith's case, he will often, when he's discharged, then receive medication, for example, by way of depot injection. And that will involve a nurse from the community health team attending his property at set intervals in order to administer that medication. So the impact to him if he were to lose his home is not only the obvious impact that applies to anybody that loses their home, but it's the fact that there is then the risk to him that he is going to then disengage with the community mental health team and in turn then become unmedicated again and potentially a danger to himself and others. So it's certainly in a housing context, and from my experience, these things really are grave matters and serious matters. Other sorts of issues that arise in a housing context often will be matters such as the duty to make reasonable adjustments. So there's provision within the Act that where a practice, policy or criterion puts a disabled person at a substantial disadvantage, then there is a duty upon a social housing provider where a request is made to make reasonable adjustments to help them to avoid that disadvantage. The sorts of things are, for example, a general antisocial behaviour policy which says where there's antisocial behaviour, we will seek possession. That sort of thing can be can place a disabled tenant who perhaps can't control his behaviour at a substantial disadvantage. I'm conscious of the time, and so I'll touch very briefly to finish the case of Ackerman Livingstone that again was referred to by His Honour, that dealt with the difference between what are generally public law human rights Article 8 defences and Equality Act defences. Again, they are becoming ever more important now where we have housing legislation that provides for mandatory grounds of possession, because in those cases generally the only defence is either one of discrimination under the Equality Act or one of disproportionality under the Article 8 rights. And so that is, again, aside from those defences, then a tenant will simply be evicted from his property with really very little discretion on the part of the judge, unfortunately. I think I've gone over my 5 minutes, and so I'll leave it there, but thank you very much.
Thank you, Karis. Our next speaker is Michael Imparato of Watkins and Gunn. He's a partner and solicitor there and has been since 2014. Michael is the head of public and administrative law at the firm, and he's also a highly regarded personal injury lawyer. Michael's been involved in some of the highest profile cases in Wales in recent years that cover judicial review, education and personal injury. He's regularly asked to speak at national personal injury and public law conferences and events and has an extensive catalogue of high-profile articles and media commentaries on his cases. He's been ranked as a leading administrative lawyer in both the Chambers UK Guide and the Legal 500 for 2019. He recently represented a claimant in a key public sector equality duty case in Wales, where the decision by Caerphilly Council to close a leisure centre was inevitably quashed. I'll hand you over to Michael.
Thank you. Like the other speakers, I'd like to thank Angharad and the Commission for this and his honour for the judicial support for today. I wanted just to touch on the public sector equality duty, which arises out of the Equality Act, and that's all about the duty on public authorities to think about how their decisions affect people with protected characteristics. And the vehicle for that often is the equality impact assessment, which the authorities, decision makers will or should carry out. And there's two cases I'm going to touch on, and they're both my cases and they're both South Wales cases, where illustrates that in practice. And the first one is a case of Tilly against Vale of Glamorgan County Council. There's no one here from the Vale of Glamorgan County Council, is there? No? Good. But that case, that was about a library closure, Roos Library in the Vale of Glamorgan. And there, the local authority had carried out a generic equality impact assessment when they first hatched the idea of closing lots of libraries and turning some of them into community libraries. So there's a very generic equality impact assessment. And then later on, they undertook some more library-specific equality impact assessments. And the Roos one identified some adverse consequences of closing the Roos Library. But anyway, when the final decision of the Cabinet came to be made, there was a report which Cabinet officials officers prepare a report for the Cabinet. And it was the report, the judge, Mr. Justice Lang, said that the report was positively misleading because it did not draw attention to the conclusions of the area-specific, the library-specific EIAs. It kind of glossed over that. And it wasn't really clear to the decision-makers the adverse consequences of the library-specific EIAs. And she also said that, again, when you see local authority documentation, they're often very unwieldy, lots of appendices and the like. And she said that members, in other words, the Cabinet members, should not be expected to research appendices for material which is significant on a decision, and it should instead be drawn to their attention in the text of the report. So it's saying that you really shouldn't just bung everything in the back of the report. It should be an engagement process in the mind of the person doing the report to put in the mind of the Cabinet making the decision. And so she was critical of the EIA process of the Vale of Glamorgan for that purpose. And then we have the case which was just touched on there in my very fulsome introduction, which was about the case of Shane Williams and Caerphilly County Borough Council, which is all about the closing of attempt to close Pontland Fryth Leisure Centre. Now, Shane Williams was a regular user of the centre. In fact, Shane was a very keen table tennis player, and that's why he used the leisure centre for his table tennis. So he challenged the decision of the Cabinet. And this is an interesting case, I think, where there had been, a couple of years before the decision to close Pontland Fryth, there had been a more strategic decision about we got to get rid of some of our leisure centres. And then a year or two later, they decide to close Pontland Fryth. So in the decision to close Pontland Fryth, they referred to an EIA, a quality impact assessment, that had been done at the time of the strategic decision a year or two earlier, and said, well, that's okay, we've got our equality impact assessment. Well, Mr. Justice Swift said, no, that's not good enough. That's not, again, showing proper due regard to your duty and looking at it in more detail, particularly as officers' reports on the closure of Pontland Fryth itself had stressed the fact that people would have to travel to get to an alternative leisure centre. And the judge said, well, that obviously means that people, elderly and disabled people, could be adversely affected by this. But because you were looking at more of a generic equality impact assessment from a strategic overview rather than the Pontland Fryth specific view, you hadn't done it correctly. He said it was striking that the Pontland Fryth decision, the position of elderly and disabled persons was not addressed in terms. So he said that the council had not discharged its public sector equality duty. So I think those are two nice illustrations of local cases in the last few years here in South Wales where councils have gone into a pickle over their equality impact assessments. And I think it's important, it shows again the working of the Act, and it also shows that pleading an equality impact assessment duty is something you should be considering to do so. And also, sometimes I think it's sometimes pleaded as a bit of a make-weight, but it actually can have real teeth and real effect in real cases. And in this case, it saved a leisure centre. So I think that's a very important use of the Act, and a welcome forums like this where we can share that information and raise the profile of such cases. Thank you very much.
Our next speaker this evening is Rachel Anthony from Civitas Chambers. Rachel was called to the bar in 2000, having had the benefit of a background of working initially in South Manchester Law Centre and then the voluntary sector in Greater Manchester, promoting the rights of those suffering with mental health difficulties. Her desire to support those with suffering with mental health to achieve a fair and just outcome has continued in her practice at the bar, with her main focus of work being with tenants who are facing eviction due to the symptoms of their mental ill health. She has a particular desire to help those suffering with emotionally unstable personality disorders, given the difficulties which often ensue from the disorder, particularly the difficulties engaging with the justice process. Other aspects of her work and practice include acting for tenants facing eviction, with particular focus on the Housing Act of Wales of 2014, court of protection work, contentious probate matters, trusts and land. Outside of work, she promotes the role of music in achieving better mental health, leading a mixed ability orchestra and teaching the violin. And she's also been appointed to the Commission's panel of counsel. So, Rachel.
I will try and keep to time. I won't promise. So I was aware when I was writing what I was going to say that I would be going last, and I would like you to bear in mind what Cara said, because obviously we both work in housing. And I'd like to build on what she said and echo it by comparing and contrasting two cases where I acted for the tenant. Largely my clients are people who have mental health disorders. Largely they are male, and a significant number of them, are convicted sex offenders. So that is a particular group that I have experience dealing with. When I'm giving you these examples, obviously I'm not going to identify them. I'm going to look down at my notes because I don't want to stray from them, because I don't want to say anything that might identify these people. But when I use gender, it doesn't mean that person was actually a male or a female person. I'm simply using it to try and anonymise these cases. So the first case is the case of A. A faced a claim for eviction by his social landlord, which I sometimes refer to as an RSL. He had significant psychiatric history. He was also subject to multi-agency public protection arrangements known as MAPA, and he had a PPO assigned to him. He had a history of disconnection with services, but at the material time was complying with psychiatric services. There was no issue over A's capacity. A was housed in a flat. A second tenant was placed in the neighbouring flat, and I'm going to refer to that person as the new tenant, and the new tenant and A had the same landlord. The new tenant had learning difficulties, substantial psychiatric history, and was immensely vulnerable. The strategy for adult mental health services in Wales recommends that every user in contact with mental health services should have a structured assessment of risk written into their case records. And that assessment is sometimes referred to as a WARN assessment. That's a comprehensive assessment which covers both their psychiatric and their criminal offending history. It should be covered by patient confidentiality and should be disclosed in a limited number of circumstances. It's also important to tell you that all social landlords should identify adults at risk and they should have policies on adults at risk and antisocial behaviour policies, as Keris has already referred to. In relation to perpetrators of antisocial behaviour, those policies should say that landlords should take certain steps for people suffering with poor mental health. The level of engagement varies. Some policies require the landlord to take a multi-agency approach, and some simply require the landlord to signpost the tenant to mental health services. Personally, I'm yet to see a social landlord policy which requires landlords to consider specifically whether their antisocial behaviour was caused by disability and then weigh it up whether it's proportionate to take eviction. But in fairness, it may well be that those excellent social landlords who write this into their policy never come to court, and therefore I never see it. So in this case, A was obliged to receive his medication through a depot injection, largely because of his history of non-compliance. Both the depot injection and the Warren assessment were carried out by the same psychiatric nurse. That same psychiatric nurse was also the psychiatric nurse who cared for A's neighbour, the new tenant. The new tenant complained about A's behaviour. He was unkempt and he or his visitors were noisy. There were issues about drug usage at A's property and concerns that his behaviour would cause a breakdown in the new tenant's mental health. For whatever reason, the psychiatric nurse made an unauthorised disclosure of A's Warren assessment in its full unredacted form to A's landlord. The landlord panicked. They immediately sought possession of the property and made statements such as, if a gun were found in this particular town, they would have no difficulty believing that it was linked to my client, despite the fact there was no suggestion that he was involved in weapons at all. The landlord failed to consult MAPA before issuing proceedings, failed to consult A's PPO. They failed to seek permission before they themselves disclosed the full unredacted Warren report by attaching it to the notice seeking possession and to the pleadings themselves. It can be readily seen in that case there was no multi-agency approach at all, as there should have been in accordance with social landlords' policies. The result of the unauthorised disclosure was a complete breakdown in the relationship between the CPN and A. A requested another CPN to be allocated to his care. When this wasn't available, he ceased to attend for his depot. His mental health significantly deteriorated, and as a result of that, he did not attend the trial date. What I would wish to highlight here is how those suffering with mental ill health face barriers in being involved in the justice process. A's legal team had taken significant steps to complain about the unauthorised disclosure, including complaints to the Health Board, to the Information Commissioner, to the police, and to 2 district judges in the early stages of the case. However, the damage was already done. We were extremely fortunate to be allocated a district judge for trial who had extensive experience both in data protection and MAPA. He'd also taken a great deal of time and care in reading the Code of Practice to the Equality Act, in addition to obvious care in reading the case papers and skeletons. He rightly found it reasonable to adjourn the trial to allow contact to be re-established with my client. Soon after the adjournment, A was detained on section, his medication was recommenced, and by the time of the second trial date, he was in receipt of support from the psychiatric team, which unfortunately still included the same psychiatric nurse. He was very concerned that because he was on section, he couldn't go home and get smart clothes to wear for the hearing. That sounds like such a small thing, but it really impeded his ability to feel part of the justice process. Because when you present to the court and you're being cross-examined, any small knock on your confidence can have a profound effect. Again, we were fortunate. The same district judge who had adjourned the case previously heard the trial. It transpired in that case that the housing officer had had no training at all in the Equality Act or in data protection or MAPA. And it was quite apparent that the landlord simply hadn't considered A's disability or proportionality. A's mental illness had caused him to self-neglect and made him extremely vulnerable to exploitation. The root of the antisocial behaviour in that case was actually people preying on A's vulnerability. Had these issues been dealt with by proper engagement by the landlord, by a multi-agency approach, they would have become aware it was a matter which ought to have been addressed through engagement with the police. As it was, unfortunately, the landlord's actions rightly appalled the police, and the police actually gave evidence at court as to why they opposed the landlord's application for possession. The concern remains as to the new tenant. She was ultimately left in a position living as a neighbour to A, and these cases are frequently appearing where adults who are extremely vulnerable by reason of their mental ill health are placed next door to each other, and judges are being asked to weigh up the needs of two people or more who are extremely vulnerable by reason of their mental ill health. Often this is without the benefit of any social service input as to what will happen to the tenant if they are evicted. In A's case, had he been evicted, he would have disengaged entirely from mental health services. He was known to self-neglect to an extreme degree in such circumstances and would likely come to significant harm. On the other side, it's certain he would have evaded supervision by his PPO, and therefore questionable as to what risks would be posed to the public if he had been evicted. That's the first case. I don't have time to do the second case, but I will hang around afterwards. That case concerns injunctions, and I would love to tell you all about it.